following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the legislative aspects of corporate governance in Sri Lanka. With the reintroduction of the IMF, the economy and supporting infrastructure has been in dire straits. Does the law protect proper corporate governance despite the situation? And have there been changes to this doctrine resulting from the current situation? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty. Now, today's topic is not something that we haven't discussed prior, but we really haven't gotten into the depths and the nitty-gritties of this specific area, and that is corporate governance. Now, I'm sure a lot of the laymen, the audience that's watching tonight, would not have had to brush fates with corporate governance in an intrinsic level, but I'm sure a lot of us have wondered now what is the ethos of certain corporations and what standards are they held accountable to? And to talk about corporate governance, I believe we have possibly the best individual in the field for this, and that is President's Counsel, Dr.Harsha Cabral. Thank you very much, Doctor, for taking the time to speak to us today on this very important topic. A brief introduction on Dr. Harsha Cabral. He is a lawyer with 35 years of practice. Our President's Counsel is also part of the member of the Law Commission and member of the Advisory Commission for Intellectual Property as well. He is the member of the ICC as well as being a senior lecturer at multiple universities, international and locally. And also he is the senior director for a large number of companies as well as the chairman of NSB recently. Congratulations on that as well, Doctor. Safe to say that, Doctor, you are possibly the most qualified individual for this discussion. So before we get into the discussion, of course, let me give you a small breakdown on exactly what we're going to be talking about. First, we'll be getting into the basics, the fundamentals of corporate governance specifically, what governs, what legislature is present, and how corporations are held accountable, the SEC as well. Next, we'll be talking about the current context, basically. With the IMF coming in, had there been changes proposed as legislature changing in this instance? And finally, we'll be getting a little bit of an insight into Dr. Harsha Cabral's very own book regarding the duties of the corporate governance and duties that boards of directors have to abide by. So we have a lot to cover.
Hello, I'm S.S. Vikramasinghe and I'm a cybersecurity undergraduate. My question is on the fundamentals of corporate governance. What is corporate governance and what key pieces of legislation surround this subject?
All right, well, without any further ado, Doctor, let's get right into the discussion. It's quite a packed discussion. There's a lot to talk about, but Doctor, I believe you are one of the most well-written in this field as well. So thank you once again for taking the time to enlighten our audience. Doctor, before we get into any of the specifics, could you please help our viewers understand the basics of corporate governance? What legislature is present in governing corporate governance and what standards are there in the legal field?
Well, corporate governance is basically proper governance. Corporate is company, governance is management. Governance, you have government, governor, so on and so forth. So it's proper management in companies is called corporate governance. Now this term came into being from 1992 in England. Sir Adrian Cadbury is the one who started this whole project on corporate governance. No one earlier discussed corporate governance. The company management was there, but no one was talking about corporate governance. Initially it was for financial management, and in 1992 he came up with a code of best practice for listed companies in the London Stock Exchange. And that gave a basic guidelines how the companies, especially the ones which are listed, should be governed, the proper governance. So basically corporate governance is proper governance, how to manage a company in a proper way, the management's role, transparency, equality, equal treatment for all shareholders. So it's the governance process by the governors. Who are the governors? Well, maybe the board of directors. So their role vis-a-vis their own organization is basically corporate governance. Now, corporate governance has gone further now. They have gone into areas like corporate social responsibility, so on and so forth. We call it CSR. Where long years ago, companies were considered good if they made profit, but not anymore, because it has to be a good corporate citizen. Now, how do you assess who is a good corporate citizen, right? So you must maintain certain standards. It has to be, you've got to look at all the stakeholders. Earlier it was, well, if the shareholders got a good deal at the end of the day, the company was doing well. But now you can't. You can't, spoil the environment and make profits. You have to look at your shareholders, minority, majority, both. You have to look after your employees. You got to look after all the other stakeholders. That is even your lending institutions and any other stakeholder who is involved with your organization, your customers, and then the world at large. So then only you are considered a good corporate citizen. So individuals have that role to play in organizations, and the biggest role is played by the board of directors.
I see. So essentially, Doctor, it's almost a code of ethics now, but it used to be completely financially focused in the historical context.
That's right.
So moving on, Doctor, now we know the SEC is a very pivotal area in which corporate governance is intrinsically connected to. Could you please explain some of the regulatory powers of the SEC when it comes to corporate governance, Doctor?
It's a very good question, because when you say corporate governance or say managing the companies, well, under the company law, now we have 7 of 2007 Our Companies Act, which has 534 sections, 13 schedules, and in that you would find no mention about corporate governance. If you go through all the 534 sections and the 13 schedules and 46 forms, you will not find the word corporate governance, right? They call the management, there is a very specific section in 184 of the Act, that shareholders have to appoint a board of directors to manage the company. Shareholders don't manage companies. If shareholders were to run companies, well, Haley's would be run by millions of shareholders, John Keel's would be run by millions of shareholders. They appoint a board of directors, and the board of directors will run the company. Now, the Act speaks of directors or board of directors. 184 I mentioned. Then the Act defines in section 529 who a director is. Now that's a very wide definition. 529 definition on director. Who is a director? Named director. Who is not a named director but who fits into that particular category, right? Sometimes a person who is puppeteering also might get caught to that, because in certain cases there are country managers. So all the directors are overseas. So who will be responsible as a director's role? So the director is defined. And then thereafter, there are a whole lot of sections with regard to directors' duties, responsibilities and obligations. Large number of duties spell out it's in black and white. In our old statutes, whether it's the 1860 Joint Stock Companies Act or the 1948 the Companies Ordinance or the 1982 Companies Act 17 of 1982, didn't have this in black and white. You had to go through case law to find what are the responsibilities, what are fiduciary duties, what are how to act in good faith. All that was emanating from case law. But now in the Act itself, there are a series of sections with regard to how a director should act. If I give you some examples, 187 says you must act in the best interest of the company and in good faith. Very simple. Then 188 says, well, you must follow the provisions of the company's articles and the provisions of the Companies Act. That again is simple. Then 189 says the standard of care that is expected when you are on a board. So now these three sections gives a big formula for the directors how to perform when they are on the board. Right? In addition, there are so many conflict of interests and so many areas where specifically says how they should perform when they are on a board. Now that threshold becomes stronger when the company is a listed company, because if it's your own money, you can do, as long as you don't cheat, you can do whatever and get away. But if you have public has invested money, then there is regulation. You see, now that is how the regulator comes in. You are talking about the SEC. What is the role of the SEC? So the securities regime is basically the Securities Exchange Commission, SEC. Below that you have the Colombo Stock Exchange, which is CSC. Below that you have the CDS, Central Depository System. So now all SEC has Act, it has its own rules. CSC has its own rules. CDS has its own rules. CDS is where you buy and sell your shares. So this is basically the umbrella of securities regime. So if the company is listed, not only the regulator who is you have the Registrar General of Companies, but you have an additional regulator, the Securities Exchange regime. All right. Now, you won't find, I mentioned earlier, the word corporate governance is not there. Then the word executive director, non-executive director is not there. Where will you find it? In your articles of association, not in the Companies Act. Then the word independent director, non-executive independent director, nowhere in the Companies Act, right? Not in the articles also. Independent director comes from the securities regime. That is where corporate governance comes in, right? Now, in addition to that, there are other institutions where corporate governance is brought in. Say if the regulator is the central bank, right? They have their own regulatory mechanisms. They have bank supervision and non-bank supervision. Very stringent corporate governance guidelines are laid down by the bank supervision and non-bank supervision. Bank means all the listed banks, registered banks, commercial banks, so on and so forth. Non-bank supervision is for finance companies, leasing companies, all those other financial institutions that come. So they have separate directives that come from the central bank, which brings in corporate governance. All those are, and then if the entity is a listed entity, insurance company, there's another regulator, insurance regulator. So this is how regulation comes in. Regulation doesn't come basically from the Companies Act. Companies Act will give the basic guideline of what the role of the director is. That becomes much bigger in a listed entity coming from all those regulators. And then going further, you would see how the securities regime introduces corporate governance. I just mentioned about how it started in England in 1992. And then in 1997, now we had not introduced any of these till that time. In companies have been there from 1860, registered companies. But in 1997, Institute of Chartered Accountants pioneered this process. How to get involved in this and how to introduce corporate governance. And they have a couple of committees headed by a lot of people. I believe the first committee was headed by Cabral, who was a double accountant. And then later on it was headed by Mr. Chandra Jayaratne. He was a very competent accountant. Then later on by Mr. Asita Talwat, and even the current committee, Corporate Governance Committee, together with the SEC, is headed by Mr. Asita Talwat. I've been in these committees for a long, long time. Still I continue to be in that committee. They look at how to improve our system, corporate governance mechanisms. So in 1997, we came up with the very first one, a code of best practice, well, first for auditing purposes, and then it went on, we came up with in 2003, the code of best practice for all listed companies. And in 2006, from 1st April, we introduced the voluntary code of best practice for listed companies in Sri Lanka. And then from 1st of April 2007, we introduced a mandatory code of corporate governance. All listed companies had to comply with that. Mandatory code was very simple. you must have X amount of non-executive directors, you must have X amount of independent non-executive directors. That is, for all listed companies, 1/3 of their board should be non-executive. 1/3 of the non-executive board should be independent. So what is independent, so on and so forth. Then they introduced the remuneration committee and audit committee. Later on, we added the related party transactions committee. Now it's an ongoing process, keep on developing, right? And whereas the voluntary code is very wide, anyone who wants can just log into the SEC web page. You will get the voluntary code as well as the mandatory code for listed entities.
Doctor, just a point of curiosity now, according to what you just mentioned, there is quite a number of regulatory committees and there's quite stringent regulations depending on each aspect or each area of whatever the institution is. Now, question of concern is, Doctor, is there any point where such regulations become so convoluted where it overlaps on each other, or is it all a streamlined process?
No, once it becomes, now generally corporate governance is good governance, that is something like the 10 Commandments or that's the law, whatever. It has to come from your heart. You know, you can't legislate to be a good boy, you see. So it has to come, you know, you maybe, if you can follow 8 commandments out of the 10, you're considered good. If you don't follow any of the commandments, well, you're not considered good. So all companies thrive to, you know, because now they have awards, corporate governance awards, sustainability awards, best corporate citizen awards. So the criteria is very stringent. The whole world gets to know that you're good. Then you have your own CSR projects, you see. So, I mean, then the world knows that this company is a good place to work, right? They follow all the corporate governance mechanisms. They have won awards for these criteria, so on and so forth. So it's more than legislation. So legislation is mine. I mean, even still, we would see the legislation that has come up is very minimal. Now, the recent, I brought that also, the Colombo Stock Exchange, just last month, I believe this month, 11 September 2023, puts out a circular number 4 of 2023, which reads as amendments to Rule 7.10 and Section 9 of the listing rules of the Colombo Stock Exchange. Now, this extends what we have. Policies to be established and maintained by the listed entities. Chairperson of the board of directors shall not be the chairperson of the board of committees. Requirement of chairperson and CEO duality. Fitness and propriety of directors and CEOs. Minimum number of directors on a listed company. The list goes on. So you need to update all these. All listed companies should follow it. I mean, some are coming, will be mandatory from 1st of October next year, right? And so you have time
continually
to
update.
Yeah, you have to keep on updating. So this is the latest, right? So this shows how well companies should be abreast of all this, and the role played by the corporate governance committee, that is Institute of Chartered Accountants, SEC, and now you see the CSC also. They look at the latest development in other countries. They look at the New York Code, all the other stock exchanges, the London Stock Exchange, and in the region, and what is best. And they introduce, I mean, you can't just wholesale bring from some other country. So piecemeal we introduce and sort of, you know, take up to an international level. Because you would see that, you know, even when the foreign players come, international people coming in to invest in Sri Lanka, I mean, they will look at our annual reports and see whether this company is good enough to work with. So that's basically the idea of regulation.
Right. I feel like that was a very insightful, a very overarching discussion and introduction, a perfectly sufficient introduction to our upcoming segment regarding the current context as well, with the IMF coming into play, how exactly that affects or how that translates into legislature for corporate governance, and if it does at all. But before we go into any of those details, let's go in for a short commercial break. You're watching Law, Land and Liberty. Stay with us.
My name is Nisreen Ali, and am Darshan misunderstood. My question is on current context. How has the present economic conditions has affected the corporate governance in Sri Lanka?
A very good evening, and you are watching Law, Land and Liberty. Just before we went in for a break, we were discussing with President's Counsel Dr.Harsha Cabral regarding the corporate governance and the aspects of corporate governance that is currently present and how it has evolved over the course of history and how it continues to evolve. Just as you mentioned a few months ago, the CSE itself has put forward new circulars, and it's a continually updating process. But I feel like Doctor, having been one of the most well-written authors in this area, I feel like you would be the most qualified individual to enlighten our viewers on exactly what the duties of members of boards or directors in themselves, what their duties comprise of, and what they are to be held accountable to do. Could you please explain to us, Doctor, with some focus on your book, exactly how a board of directors can be held accountable?
Yeah, what I would say is that I have, in my book itself, it is now written for some time back, but it's almost the same. The director's duties, and in fact, I have a little chapter where I have set down in writing what I call it the tips for any director, you see. So I've called it, say, some golden tips for directors. So I thought I will just share it with you so that that covers most of it. These are some valuable tips for any director. Be mindful of accepting directorships. Do not take over past sins of others. Do not join rogue clubs. Check the history of the company before joining the board. I mean, I myself would look at least about 5 years annual reports backwards. Act in the best interest of the company at all times. Always act in good faith where your bona fides can be established easily when in doubt. Never act in a reckless manner whilst on the board. Never act in a grossly negligent manner whilst on the board. Always rely on your experience and knowledge in business judgment. Do not let your personal interest conflict with the interest of the company. Familiarize yourself with the important provisions of the Companies Act, which can have an impact on your actions on the board. Because sometimes some boards might have one lawyer, you see. So just because it's a law, you should not ignore it. Familiarize yourself with the provisions of the Articles of Association of the company. It's very important. At least the director should know what the articles are. Note that the Companies Act, it is specifically stated that the provisions set out therein are in addition to and not in derogation of any provisions contained in any other law relating to the duty or liability of directors or officers of a company. I just mentioned about the SEC Act. Ensure that all statutory obligations of the company, example EPF, ETF, taxes, are complied with forthwith. I would say compliance check either monthly or quarterly. Ensure that all banks and other lending institutions are serviced accordingly. Compliance check either monthly or quarterly. Regularly check whether the risk management techniques of the company are in operation. There are so many risks now. Enterprise risk, strategic risks, financial risks, yes, political risks, so on and so forth. Note the significance of several other important provisions of the Companies Act that deals with vis-a-vis company name and company number, special provisions applicable to private companies, the solvency test, distributions, stated capital and capital maintenance, reduction of stated capital, dividends, financial assistance by a company for acquisition of shares, minority buyout rights, meetings, proceedings and resolutions, major transactions, etc. Check whether the financial reporting is done in a professional manner under the provisions of the law. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the Securities and Exchange Commission Act and the SEC rules, which can have an impact on your actions. If the company is listed on the stock exchange, make sure that you are aware of the provisions of the listing rules of the Colombo Stock Exchange, which can have an impact on your actions. I just referred to one, the latest one. If the company is listed on the stock exchange, make sure that you are aware of the mandatory code on corporate governance and also the voluntary code on corporate governance. Even if the company is not listed, try to follow the corporate governance mechanisms in place for good governance. Consider the mechanism of CSR, corporate social responsibility, for the company. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you are aware of the provisions of the Banking Act, which can have an impact on your actions. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you are aware of the provisions of the directions made under the Banking Act, which can have an impact on your actions, example, corporate governance. If the company is a licensed commercial bank or a licensed specialized bank, make sure that you are aware of the guidelines for internal controls published by the Institute of Chartered Accountants of Sri Lanka. If the company is a registered finance company, make sure that you are aware of the provisions of the Finance Companies Act and directions made under the SECD Act, which can have an impact on your actions, example, corporate governance. If the company is a registered finance leasing company, make sure that you are aware of the provisions of the Finance Leasing Act and directions made under the SECD Act, which can have an impact on your actions, especially corporate governance. If the company is a specialized entity, make sure that you are aware of the provisions of the statute or statutes which can have an impact on your actions in addition to the provisions of the Companies Act referred to above. Now, for example, I'm on the NSB. Now, NSB is Act, National Savings Bank Act. So if I don't know the provisions of the Act, I'm not suited to be on that board. Be mindful of your actions that can be impeached by the company, directors, shareholders, creditors, and other stakeholders under the provisions of the Companies Act. Be mindful of oppression and mismanagement actions and derivative actions that can be instituted by minority shareholders, impeaching actions of directors. If the company is a conglomerate or a group entity, ensure that you have a fair knowledge on holding companies, subsidiary companies, and associate companies and their respective roles under the law. Check whether the consolidated accounts or group accounts are done accordingly if it is a group entity. Avoid any Selinco consolidated scenarios. Be mindful of related party transactions of the company. Example, avoid any golden key scenarios. Ensure that all disclosures are made under the law. Use your conscience when taking decisions at board level. Make use of your own expertise when you have a superior knowledge on the subject. Never let others who are lesser knowledgeable on the subject matter in issue pressurize you to change your decision. Always ensure that the independent directors are truly independent. Always ensure that the board recognize the views of independent directors. Do not be under obligation to the chairman or any other member on the board. Have an independent mind of your own. Ensure that your dissent on any matter is recorded correctly at meetings. Check the board minutes and minutes of other committees where you are a party with care. Read the board minutes with absolute care before they are confirmed. See that board minutes and other minutes of committees are corrected accordingly. Note that board minutes are treated as a contemporaneous record of events and matters. You might be able to use it 5 years later in courts. If you are not an expert on the matter in issue, ensure that you rely on third-party expertise on the matter, either at board level or externally. Keep records of same for safety purposes. Use of information and advice of third parties is permitted under Section 190 of the Companies Act with clarity. Any individual on the board can rely on third-party expertise in given circumstances. Always remember to keep such advice on record to be used as evidence when needed later. Legal opinions, emails, etc. Be aware of the provisions of the Companies Act and other relevant statutes which attract personal liability, including criminal liability, which again is personal in nature. Make use of the directors and officers insurance cover, which is known as D&O insurance cover. Ensure that a proper interest register is maintained by the company and all relevant interests of directors, including yours, are duly entered in the said register. Make use of Section 526 of the Companies Act, power of court to grant relief in certain cases when needed to obtain appropriate relief from court. Make note of actions that attract personal liability, civil and criminal both, as set out in the other statute or statutes that can impact on the company. Ensure that all your actions are carried out in a professional manner, reasonably with dignity and honesty. Independent non-executive directors are invited to boards mainly due to their expertise. Example, expert in finance, expert in law, expert in marketing, etc. Ensure that such expertise is made use of by the board and not ignored. If you feel uncomfortable on the board, exit forthwith. Independent directors should resign no sooner they feel their independence is eroded. Do not accept board appointments if you cannot dedicate sufficient time for board matters. Do not accept too many directorships if you cannot dedicate sufficient time for each directorship. Be aware of your rights as a director under the Companies Act. Example, privy to board minutes, etc. Check whether the CEO, Chief Executive Officer, is performing his obligations correctly. Check whether the subcommittees of the board, example, audit committee, remuneration committee, nomination committee, etc., are in operation in correct manner. Check whether the company external auditor is performing his rights professionally. Check whether the company secretary is performing his rights professionally. Ensure that the internal audit mechanisms of the company are in order. Be familiar with the Sri Lanka accounting standard SLAs that may have an impact on your company. Also note that Sri Lanka is following IFRS from 2012. Avoid being a mere passenger on the board, endorsing all decisions of the board in a passive manner. Be cautious when giving personal guarantees for corporate benefit. Remember that ignorance is no excuse. Remember that accepting a directorship is not joining a cocktail circuit. Never discuss boardroom matters with family members. Never discuss boardroom matters with friends or associates. Do not disseminate price-sensitive corporate information to any third party who is not entitled to know them. Do not trade your principles for money. So this basically is a litany for any director, who is on a board, whether it's listed or otherwise, because you're a responsible person on the board. That emanates corporate governance.
Of course. Now, Doctor, we have just gone through, I feel like it could be considered the commandments or the constitution. Absolutely. For one individual director or board of directors in order to, it's basically a consolidated code of ethos, ethics, and it's very essential that our viewers understand exactly what was relayed to us right now. Thank you very much, Doctor, once again for taking the time to actually read off your book and let us know about these essential commandments, I would say. Now, Doctor, moving on, there is a lot of tension, a lot of basically concern regarding the current context in the country as well. And that is, of course, with the IMF coming into play. Now, Doctor, with relation to what you just mentioned, there's a lot of financial and also managerial responsibility that falls upon a director's shoulders. Could you explain to us exactly how that translates in the current context when it comes to these stringent measures proposed by the IMF and what the economy is facing right now? What exactly could we take from the book and translate when it comes to being a director in the current context?
Long before the IMF came, this Companies Act 2007 was introduced, and in that we introduced a couple of new sections, like sections 57, 58, solvency test, right? And then the 219, 220, we are in a winding up situation, how directors should act. In a situation in 220 where there is serious loss of capital, how they should act, tighten your belt. So the law provides for situations like what we had maybe 20, 21, 22, all those years, maybe for COVID, maybe for the financial crisis, right? So the companies, prudent companies will always have risk management, right? So they would know how to steer through in troubled waters. So that has to be, that is a competent board would know exactly. I mean, very few companies closed shop and ran away because of COVID or maybe because of the financial crisis. And now they are little by little getting out of, there are trouble periods. Even an individual, if you look back at your life, you will have trouble periods. There are good periods, bad periods. So that is how you have to structure it. But now, well, with IMF and new laws coming in, one is insolvency. Now we are looking at that. The World Bank is supporting the Ministry of Justice. We are involved, tomorrow, day after, also full day we are with the World Bank team, trying to study and see how best, because our winding up rules or the winding up law we have in our Companies Act is totally archaic, right? We have two types of winding up, members winding up and creditors winding up. It's like basically the undertaker's role of giving a decent burial. Now, when in other countries, like in the US, they have Chapter 11. In India, they have Sikh Industries Companies Law. Then in Malaysia, they have the Danaharta model. Restructuring, in bankruptcy, downsizing, retrenching, selling off certain assets to keep going, right? So the companies have to steer through all this in a very, very careful manner.
There's a concept of salvaging that's not present.
That's
in the
right. So even in a human being, we don't let the person die now. You have, so many mechanisms to keep him going. So now those are to be introduced. So that's the area we are looking at, because we have seen certain collapses, right? Internationally, we have seen Enron, and in India, we had Satyam, and Sri Lanka, we have so many, including Golden Key. Right? Now after Enron, there was a new law that came, the Sarbanes-Oxley Act in 2002. Now this has been there for almost 21 years, right? This basically is corporate governance. Basically, I have Sarbanes-Oxley simplified. Is it correct? Are you sure? Can you prove it? Right? Because this gives certain guidelines how companies should be maintained, especially in difficult times when you go into, it's interesting. I will just very briefly touch on that. In the Sarbanes-Oxley simplified, in this, it says, investors and creditors relied on public companies' audited financial statements to make investment and lending decisions. Right? And it goes on to say, investors felt betrayed by the accountants and auditors they depended upon to be gatekeepers. Now, these are very important. The I didn't know defense is not accepted anymore. Right? So, directors, when you are directors on the board, you can't say I didn't know. You can't say I didn't know what was going on in the country. Now, this was brought in to strengthen corporate governance and to restore confidence, investor confidence. Ignorance is no longer an excuse. So, boards of directors should be responsible individuals. Like governing a country, the cabinet of ministers should be responsible. If they are irresponsible, we know what happens. Right? So, in the same way, companies, I must say, during the most difficult periods of the recent past, some companies have done very well. Right? I can give you the example of Haley's. Right? They made a 42 billion profit during the last financial year, when there were so many, they are the highest ever profit they made, because they had, not only tourism was dead, but they had exports like activated carbon. Then they have 5% of the, the glove market from international market. So those are the ones. Then logistics. So those, you want to be ready. You not put all your eggs in one basket. So companies, the companies that have survived are with strong boards, intelligent boards. Right? So that's how, even after COVID, a lot of countries have come out of it, because they are very strong. We don't have to go far. Singapore government, competent government. So we need that, like having a competent government. You must have a competent board, and that would control the company and take to better destinations. So that is corporate governance ultimately.
But sir, a question building up on that. Now, when it comes to the fact that now companies such as Haley's has done extraordinarily well despite the current situation, do you think the good governance aspect translates directly to dividends, or is there no such connection, or is there not as strong of a connection? What are your thoughts?
No, good governance, the return of good governance will be satisfaction. So the satisfaction will include profits also. If the company makes good profits, they can declare good dividends. Then all your shareholders will be happy. Your employees will be happy. All right? You looked after all the employees. There are a couple of companies during the toughest periods, they provided transport. Well, you had no way of coming. There was a shortage of petrol. Right? Certain mechanisms. I know one particular organization, they had 18 buses coming from all over Sri Lanka, collecting these people, giving them vegetable packs, right? Whole lot of mechanisms. So that's why ultimately I say CSR, corporate social responsibility, the other end of corporate governance. You do something more than your normal business, right? You see Uttara doing the cleaning, washing those dogs on a Sunday, which is called the Embark project. And nothing to do with the clothing business, right? So that is a CSR project. I know Haley's, they have, Sadyavara project by Haycab, providing water in those difficult areas where there is a lot of problems with drinking water. Tokyo Cement, we have our own projects, safety of looking after the corals, and also feeding students. We feed a large number of students in North and East. Not only manufacturing cement, nothing to do with cement. Now those are projects. Haley demos may have bringing down the carbon footprint. I don't know, LOLC, they are doing this kidney dialysis free of charge. They have 2 places. Nothing to do with their normal business. So if you are doing well, you will be able to do something for the society. That is basically corporate social responsibility. You are considered a good corporate citizen, right? Because that nature of, giving, you got to be blessed to give also, right? So that blessing will come if the company is a good place to work.
A firm foundation with good moral values
Absolutely.
will translate to good results as well. I feel like that would be true in any case across the spectrum, no matter corporate or in personal lives as well. Now, sir, just a question regarding the international context. Now, I understand that we are currently looking into possibilities of adopting different models of restructuring processes, how not to just give up on companies that are struggling and to, completely try and salvage what is left. Now, on an international context, Doctor, how do we compare when it comes to, of course, powerhouses, global powerhouses, the West, and of course what's in the East, China and all. How do we compare, of course not on the same scale, but do we actually have even footing, or do we have a very long way to go?
No, if we have the proper mechanisms, right now, for example, business recovery, how to assist such companies, sledgehammer approach of, winding up and appointing a liquidator and closing shop is not the way to set about. Difficult times, you've got to help them, there are mechanisms like, all the stakeholders will join the party, right? The lending institutions will say, okay, we'll give you some breathing space, right? Get some good people to run it in the interim. If you have no faith in the old board, get up proper, we have administration mechanisms are there. The new laws will look at all those. There will be a moratorium for a short period, try it out. Then you might have to downsize, right? You have to maybe sell a few assets. Well, when you're doing well, you buy new assets, right? Your capital expenditure will be very high. And in difficult times, you got to move, and so that change is needed. So that is where the proper governance comes in. That's where the board will have to be, competent, take decisions then and there, right? I mean, you tighten your belt, right? We know that how we went through the last financial year. But I mean, now people have forgotten, right? I mean, when there was a shortage of fuel, there was a quota system, right? So the same way it applies to corporates as well. So there got to be very, very professional management and honest, ethical management as well. Right? So you have to know. That's why I always say you've got to end this menace of corruption, especially in the public sector. You don't find that much in the private sector, but they would help the public sector to get things done. So that then discipline, lack of discipline and corruption, unless you bring it to the corporate world, no amount of corporate governance mechanisms would work. So I would say in the both public sector and the private sector, we have to inculcate that culture. And if they can achieve that, well, future is good. That's why I always say, when I lecture to my younger lawyers, I always say that's the future. When you don't try to change the system in the olden system or the senior lawyers or whatever, you're very young, you think differently, right? So you will be able to achieve it. So same way corporate governance mechanisms also in new era, I mean that's something that is developing and going forward. I'm sure the corporate world will benefit if proper corporate governance mechanisms are introduced, and like internationally, locally, and for the individuals as well.
I see. While that is quite a good point to leave off on this topic, Doctor, I feel like there's one more question that I would like to ask you regarding shareholder rights. Now, when you mention that tough times will call for tough measures and we'll have to tighten the belt, save the boat somehow, do shareholder rights have any sort of impact in that instance? Now, in these instances, does shareholder rights actually face any issues?
Yeah, because one of the major shareholder right, whether it's majority or minority, is to get a return for your investment, right? So ordinary shareholder would get a dividend. Now the company should make profits to declare a dividend, right? Now during the last 3 years, majority of the companies had to merely survive. So they couldn't pay out dividends. So shareholder will be affected. So they will have to also be careful, be conscious, be patient, how to get through. Unlike if you get a debenture or whatever, you are sure of the return. But if you are an ordinary shareholder, you are the risk-bearing shareholder. But in good times, you will get much more than the other person. So the shareholders, it's the responsibility of the board of directors to see that the shareholders are also kept happy. You should not go on expanding. You should not go on capital expenditure that is not so important at the cost of the shareholders. So the shareholders, with the majority or minority, should be happy always, because if your children are not happy, the family is not happy. You see, so the same way, the company is also management, and the company should ensure that not only the shareholders in corporate governance, all your stakeholders are happy. You can't keep the shareholders happy and keep the employees at bay. The employees must be happy. Now all these companies, new companies, the new taxes have a severe impact on the employees. So you've got to see ways and means to keep them happy. So coming back to your question, shareholders are a very, very important feature in this corporate world. So they have to be kept happy, but they will also be patient in difficult circumstances, minority or majority both. So ultimately it is the proper management, proper, transparent, good management. Then when the shareholders and the employees also know that there is management that is concerned about them, right? Whether it's private sector or public sector, I give the prominence to the employees, because they have to leave first to take this company forward. And whatever possible ways, maybe some companies, they have not given anything because of this 2-3 years of difficult times. But we got to keep in mind, in good times you look after them, and they know they will not leave you, right? It's a simple thing. If the Japanese system is generally for lifetime, they are working in one organization. They don't leave the organization. It's your own employee also. If you have an employee who has been with you for years and years, that shows that you are a good employer. So that should be the management style of, make sure that they are with you.
Of course, the employees are the hands and feet of the organization after all, and good governance ensures that there's a healthy body overall, and there's sustainability when it comes to all aspects of the corporation.
Absolutely.
Well, unfortunately, Doctor, the time we have to discuss this topic has come to an end. Once again, thank you so much for explaining to our viewers regarding this very complex topic and breaking it down potentially for anyone that is watching. Maybe they could be part of a board of directors as well. They might have learnt a thing or two regarding the ethics and how to run and how good governance translates into good corporations and in the end good dividends as well. Thank you very much, Doctor, for taking the time.
Pleasure. Thank you.
All right, well, corporate governance may be the concept which has seen changes over the course of our history. However, its purpose continues to ring true in holding entities accountable for their actions. Much like this, we citizens must also strive to maintain individual standards to reflect the ethos of our nation. We leave you tonight with the words of Pratibha Patil, who is a former President of India. Financial institutions, the corporate world and civil society all must uphold high standards of probity in their working. Only a genuine partnership between the government and its people can bring about positive change to create a just society. That is all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/OtherThanEnglish. Thank you for watching. Have a great night.